do the same thing, but you just make squares, put the numbers there. You put the numbers in these spaces, and then you make your notes, and you say who's good or bad for your case. And so now you're going through the questions, and just quick update. Plaintiff, that's the first person to file a petition. Defendant, that's the victim or the second person to answer. So that's what you file, an answer after the petition. The petition says, can I have ice cream? The answer would come from the refrigerator that says there's only a little bit left. Please don't let them have it. And so that's the part. The plaintiff has the burden of proof. You know what that means, Alice? Burden of proof? No, okay. So, if you have to take tests in school?
Yes.
Okay. You have a burden of proof to prove you read the book. So if you have a book that you read, and you have a test over that book, you ever have that? Or better yet, easier. Spelling words, right? You have spelling words sometimes?
Yeah.
Okay.
I have textbooks and
yeah.
I haven't had a spelling test in a while.
Okay. Well, let's go with books then. Yeah. So books. You have a
burden
burden of proof to prove that you read the book by taking this test.
Yes.
They don't assume you're right. So same thing with the plaintiff, the first person, you have to prove that you're right. They don't assume that you read the book. Yeah. So that's what that is. The right jury, very difficult to lose. I say you can't lose, but you can always lose, but you can. And then use the rules to your advantage. That's what we talk about in the negotiations, that sort of thing. And you have a right not to self-incriminate, so you have a right not to tell on yourself. So that helps. Here we go. Jury selection. It's like speed dating. You know what speed dating is, Alice? It'd be like speed friending for you. You know what that is?
Taking a friend really fast.
Really fast. Like you don't get to talk to them very long. You don't get to sit in class with them. You're like, hi, how you doing? My name's Gerard. How are you? What's your name?
Alice.
Do you want to be friends?
Yes.
There we go. Speed friending. Me and you.
Oh, I get it. So you're meaning you shouldn't pick a jury really fast?
Well, no, saying you have to figure out really fast with who you like because you don't have a lot of time. It's speed dating, so speed jury selection. Because they give you a set of time to find out if these 15, 20 people are good or bad. So if you do the math right, because if you think about it, if there's 20 people, and let's say the judge gives you 30 minutes, there's 2 people, so 10 for the plaintiff, 10 for the defendant. There's 20 people, that leaves you 30 seconds with each person to figure out if you like them or not. So it's a short, no, it's difficult. So that's why you need a chart. That's why you got to kind of come in with questions that you. So you're going to come tell your story. So you're going to use hypotheticals. Diane, do you remember what hypotheticals are?
That's like not true. Well, no.
Yes, yeah, you're right on the edge. It's you're using a untrue example, an imaginary example to prove a point. And so I'll give you an example. In mine, and when I was using when I was on cross-examination with the officer, I gave him a hypothetical situation. I said, if you're in a situation and you could slow down, or you could maintain speed, and the situation continues to escalate, or you could speed up and de-escalate the problem, what would you do? And so his answer was he would speed up to de-escalate the problem, which was useful for my case. So you want to use those hypotheticals to find out about people during the speed dating process. So if I'm right, so let's say it's a speeding ticket, and I want people that are fellow speeders on my jury. So what I would say is, I'd say hypothetically, which one of you jurors normally just drives the pace of the pack? Who just drives with however fast the cars around you go? And someone would raise their hand, and I'd say, juror number 3, do you just go to speed whatever everyone else is going? Yes, I don't want to slow down the pack, that sort of thing. So great. I make a note on my chart. Juror number 3 is good for me. So you can use those hypothetical situations to tell them about your case, to give them a preview about your case, and find out if they agree with it in advance. Encourage bad news. Diane, do you like to tell people mean things? You like to tell them you like?
No.
No.
Do you like to tell them I don't like you? Do you?
I know.
Generally, no.
Right. And so you've got to encourage this jury to tell you early in the speed round if they don't like you, because you need to know that before you're in the case. So you kind of comfort them in the, hey, it's okay, it's no big deal. I just need to know who just pays their tickets. Who just pays their tickets, and you're a little upset that I have you here today. Okay, juror number 5. Okay, got it. Make a note. Juror number 5 doesn't like here. And then I'm going to probe a little further. Hey, are you biased against my case? Yes. Perfect. They say they're biased against your case. They can't be on the jury. So you've gotten them off. So you're now working towards getting user-friendly people on your case.
Oh. Now
So,
I understand.
and then you want to think outside of the box. You want to think, who's your friends? Who do you know in this courtroom? Who are you related to in this courtroom? Because if you don't ask that question, it could be the police officer or the person on the defense could be their best friend, and they're getting on the jury to do you in. So you need to, even though you wouldn't think anyone would know, or you would think they'd say something, you need to ask that question. Is there anything I need to know? Do you know anyone in here? Have you heard of anyone in here? Are you a fan of anyone in here? You need to know how they feel during this speed round. So once you find one, you say who else. So that keeps you from having to ask the questions that much, speeds up your time getting stuff done. Tell the judge at the end who's bad for you. That's the jury selection. That's when you start going back and saying people are biased and you need to take them off. Yes.
So how do you have that much? How do you ask those questions like in a quick way?
Yes. So I think so. The thing is to ask general questions and then ask who else. That's so you don't have to ask the question as fast, but you get more people each time you ask a question answering. So the time is on the answering, and so you may, if someone was talking too long in their answer, you may have to say, "Excuse me, ma'am, thank you very much. You answered my question. You're doing great. I'm going to move on to juror number 6, see what they have to say." Because if they're talking too long, you may lose time. So that's the thing.
Okay.
All right. After jury selection, your direct control is over. That's your direct control on the case. You pick the people. You've talked to the people. After you've sat them, that's it. So that's a key line there. It's a key step that now you don't have any more control. Direct control. So you want to, if you're going to settle or do away with something, or just know at this point, you lose that control. Begin filling in the blanks in your story. So we talked about the hypothetical during the with the juror. We have these jurors that already know that kind of what the case is about. Now I'm going to tell them the rest, and that side of your story is called a case in chief. So your case in chief is your story, and keep it in a story format. Alice, when you're reading a book, is it easy to remember that, or just memorize a whole bunch of words that don't go together?
Just memorize that, because you memorize the rest. It's just
Yeah.
you're gonna forget a lot.
Right, it kind of flows together. You remember, oh, well, Mickey Mouse did this and then did that, and you kind of, the story flows a little versus just random words that don't go together. So stay away from words that don't go together. Tell them your story. My story on the speeding ticket was I merged on, it was a road rage situation, and I was trying to de-escalate the situation. So that was my story, and it made it easy to follow, easy to identify with. Knowing and doing. Think before you answer. If I said, Diane, if you say yes, then you have to run in a circle for 30 minutes.
Oh, no.
And the question is, and the question is, let's see, what's a good example? The question would be,
I don't know.
do you feel running is great exercise?
No.
That's right. Excellent. Because I don't, that's subjective. You could think, I don't want to run in circles. And the answer, if I say yes, I'm going to have to run in circles. I don't want to, so running no is not good exercise for me. Maybe for everyone else, it may be in a different scenario, but given the set of facts I have, no. And so that's true. I don't want to run in circles. True statement. I don't think running is good exercise. No. And so that's what you want to think before you answer. You don't want to tell yourself to incriminate yourself. That's why a lot of people don't take the stand in criminal cases, because I'm not trying to help the other side out. So when they get their chance to ask you questions, then you need to think before you answer.
So you just don't want to say something right away?
Yes.
Like, yes, I do.
Yes, exactly. You want to think about it and know. So know if you don't know. So if I don't know. Hey, do you think, because you don't want to guess. If I guess wrong, I help the other side. So you don't want to guess. And none of your witnesses want to guess. When you talk to your witnesses, don't guess. Either you know or you don't know. And so keep it as that's the thing. Cross-examination, that's when you get to support your story with their witness. They have a witness there. Like I used the example of a police officer. That witness was there to say bad things about my case and help his case. But I use that hypothetical to have their witness say good things about my case. And that's what you want to do. Use that, again, hypothetical situations. Okay. Closing time. After that, after each side has asked their questions, each side has had their case in chief, you have closing time. So this is where you're going to remind the jury of your story. Again, just like in the opening statement, here's what I'm doing. Then you're going to tell them why you were right. Here's why I was right. All the witnesses agreed with me. When we talked in voir dire, you agreed with me. And then you're going to tell them what the other side said that helps. This is what their witness said during cross-examination. And then you'll go into what do you want? Because you got to give them instructions. And so, for example, Diane, how much do you think is a high hourly wage? What's the number for high hourly wage?
$1,000.
$1,000 an hour. Okay. And what if I wanted $2,000 an hour compensation? If I said I lost 3 hours of time and I want $2,000 of compensation, or I want $1,000, whatever that number is, make it known. Don't leave it to the jury to assume. I don't want the jury to say, here's $1,000 an hour if I want $2. So I want to tell them what I think should happen. I think you should award me $2,000 an hour. I spent 3 hours. That's $6,000 that I think you should come back with that as an award for me. And what that does is it kind of sets a tone, allows them not to guess, and you give them the math when they're in the room kind of deliberating and thinking. They have an opportunity, well, she said this, and that's true, and kind of helps prime the pump, and then you want to thank them for their time. Thank you for being here. Appreciate all your good information. I'll tell you as we go back, we're going to always take the deal, because you have control over that versus a jury of strangers that may or may not side with you. The system may go wrong, whatever that is. So you want to take the deal if ever you can get close to a number that you think you can live with, or I think you should take the deal.
Makes sense. Why you don't want to let them guess, because that's
right.
Not really going to work.
Yes. So we're at the question phase. I have a couple of things I was going to show you as well. So when we're leaving, I'm going to leave you with this. This is the court information for the justice of the peace. This is where you would file. This is where you would file your small claims court hearing. So I'll leave you with that. I'm also going to show to the camera. I'm going to leave you with this. This is their template for filing a case. There you see right there, it says petition small claims case, and then this is another petition they have on their website, another example, and it's a petition for relief under section, so this is a debt release. So we have these these three things that we're going to leave you with. So we'll do that after the presentation. And right now, questions and answers about something that we discussed today, or just general legal questions. Here's my contact information. I'm happy and I'm committed to working with you throughout this process and going forward. If you have questions, I want to help where I can. But thank you for your time, and let me know do we have any questions?
No.
Okay, very good. Well, thank you again for being here today. I'll get these documents put together. Thank you all very much. And I'll have some questionnaires and evaluations I'll ask you to fill out as well. So Thank you very much for your time. I hope you enjoyed the presentation because I enjoyed you.